Brothers and sisters, ladies and gentlemen, students, scholars, teacher trainers, professor professionals, officer, official listener learners. I welcome all respected Dr. Jen directors. I welcome all honorable minister managers. I welcome all adorable advocates, advertisers, and student advisors. I welcome the most honorable representative Mr. Modi ji. Really nice time, nice place, nice section today that we are describing, explaining our holy Indian spiritual cultural identities in the form of unity and diversity. International Seabed Area. What is its definition and what are the limitations of the area? The first essential requirement of a legal regime of the international seabed area is that the precise limits of the area should be clearly defined and they should be limited from other maritime zones. The area has been defined as the seabed and ocean floor and subsoil thereof beyond the limits of national jurisdiction. A pertinent question thereof therefore arises as to what is the outer limit of a coastal state's jurisdiction in seabed. The first and second UN conferences on the law of the sea failed to solve this question satisfactorily. The first UN conference on the law of the sea, which was held in Geneva in 1958 and which adopted four conventions, including the Convention on the Continental Shelf. It need not be overemphasized here that the outer limit of the continental shelf is the limit where the coastal state's national jurisdiction in seabed ends. Beyond the continental shelf, the sea bottom falls away more steeply into deep water until it levels out again in the floor of main ocean basins, which lie as much as 10 or even 15,000 feet below the surface. The area may therefore be defined as the seabed and ocean floor of the sea and subsoil thereof beyond the continental shelf of a coastal state and extending up to the continental shelf of other coastal states. But $1 million question is as to where the continental shelf ends. We have seen earlier that a definition of the continental shelf contained in Article 1 of the Geneva Convention on Continental Shelf 1958 is vague. The elastic clause of the definition providing the explorability test created great confusion in this field. An effective and workable definition of the area is contingent upon a workable definition and agreement on the continental shelf. It is heartening to note that Article 26 of the UN Convention on the Law of the Sea 1982 has removed the ambiguities of the earlier definition. As regards the outer limit of the continental shelf, Article 76, paragraph 5 now provides that it shall not exceed 30-50 nautical miles from the baseline from which the breadth of the territorial sea is measured, or shall not exceed 100 nautical miles from the 2500 meter isobath, which is a line connecting the depth of 2500 meters. It may be added that since the continental shelf comprises of the seabed and subsoil of the submarine areas that extend beyond the territorial sea, its definition and delimitation is contingent upon a workable definition and agreement on the territorial sea. There is, however, a general consensus of states that the breadth of the territorial sea of a coastal state should be up to a limit not exceeding 12 nautical miles. Measured from baselines, the limit has now been adopted in the Convention on the Law of the Sea 1982. The area comprises of the seabed and ocean floor and subsoil thereof beyond the limits of national jurisdiction. The seabed and ocean floor beyond the limits of national jurisdiction begins where the outer limit of the continental shelf of a shelf ends. According to Art 76 of the Convention, all coastal states have a continental shelf to a distance of 200 nautical miles from the baseline from which the territorial sea is measured, where the outer edge of the continental margins does not extend up to that distance. In case of states whose continental margin extends beyond 200 nautical miles, the continental shelf shall not exceed 350 nautical miles or shall not exceed 100 nautical miles from the 2500 meter isopath, which is a line connecting the depth of 2500 meters. Development of the law relating to India. The credit of taking the initiative to move the machinery of the UN for revision and progressive development of the law of the sea goes to Malta, who in 1967 proposed the following in the General Assembly. Declaration and treaty concerning the reservation exclusively for peaceful purposes of the seabed and the ocean floor underlying the seas beyond the limits of the present national jurisdiction and the use of their resources in the interest of mankind. When the General Assembly met to consider the proposal, the representative of Malta moved for the deletion of the words declaration and treaty in view of the concern of certain delegations who thought the emphasis on legal objectives was premature. In pursuance of the proposal of Maltese government, the General Assembly established a 35-member ad hoc committee on December 18, 1957 to study the peaceful uses of the seabed and ocean floor beyond the limits of national jurisdiction. Subsequently, it was replaced by a permanent 42 members UN Seabed Committee to study the peaceful uses of the seabed and ocean floor. Its membership was increased to 86 and 91 in 1970 and 1971, respectively. Later on, for substantive work, the committee was organized into three subcommittees. These subcommittees were entrusted with the task of making substantive work for the preparation for the third conference on the law of the sea. A great landmark in the development of law relating to the area was the adoption of the Declaration of Principles of International Law governing the deep sea floor, that is international seabed area, by the General Assembly on December 17, 1970 on the basis of the report of the UN Seabed Committee. It was adopted by a vote of 108 in favor to none against with 14 abstentions. The declaration contained following principles. One is declaration of the area as common heritage of mankind, two is non-appropriation of the area by states or person, three is no claim, exercise or acquiring of and the declaration of principles. For a availability of the area to all states exclusively for peaceful purposes. 5 is regulation of activities of states on the area in accordance with principles of international law, including the Charter of the UN. 6 is exploitation of the resources for the benefit of mankind as a whole. 7 is reservation of the area exclusively for peaceful purposes. 8 is establishment of an international regime to be established by an international treaty of a universal character, generally agreed upon. 9 is international cooperation in scientific research for peaceful purposes. That is prevention of pollution and contamination and protection and conservation of natural resources. 11 is due regard to the rights and legitimate interest of coastal states. 12 is the proposed international states. 13 is the responsibility of states to carry on the activities in the area in conformity with the international organization to be established. 14 is adjudication of disputes in the area. 15 is moratorium on the exploitation in the area until the establishment of an international regime. Declaration of the area and its resources as the common heritage of mankind. As declared in the first paragraph of the operative part of Resolution 2749 25, dated 17 December 1970, the seabed and ocean floor and the subsoil thereof beyond the limits of national jurisdiction as well as the resources of the area are the common heritage of mankind, as remarked by the late Ambassador H.S. Amara Singhe, formerly President of the Third UN Conference on the Law of the Sea, in his Beckett address to the Fifth Annual Conference of the Law of the Sea Institute, June 15 to 19, 1900 to 70. The concept of common heritage of mankind as we understand it is in effect the concept of property held in trust for all mankind, property which belongs to no single nation but to the entire world. The main objection to the common heritage concept seems to be based partly on the fear that some of the heirs to that heritage might carve out what they regard as their share. This is a misunderstanding of the common heritage concept. An essential feature of the concept of common heritage is the individuality of that heritage. It is the acceptance of the principle of individuality that a rational means of an equitable sharing in the benefits resulting from the exploitation of that heritage could be ensured. The principle of common heritage of mankind has become an indispensable principle so far as the area and its resources are concerned. Reference may be made here to preamble of the Antarctica Treaty which recognized that it is in the interest of mankind that Antarctica shall continue forever to be used exclusively for peaceful purposes and shall not become the scene or object of international discord. Thus, the Antarctica Treaty, though very near to it, stopped short of declaring the Antarctica as the common heritage of mankind. However, the principle of common heritage of mankind has been extended or applied in other fields also. For example, Art 11, paragraph 1 of the agreement governing activities of states on the moon and Other Celestial Bodies 1979 incorporates this principle in respect of moon and its natural resources. Article 136 of the UN Convention on the Law of the Sea 1982 incorporates the principle in the following words. The area and its resources are the common heritage of mankind. This principle also finds mention in the preamble of the convention. Paragraph 6 of Article 311, which deals with relation to other conventions and international agreements, provide states parties agree that there shall be no amendments to the basic principle relating to the common heritage of mankind set forth in Article 136 and that they shall not be party to any agreement in derogation thereof. This is indeed a very important provision and by its adoption in the Convention on the Law of the Sea 1982, the principle of common heritage of mankind has risen to the status of just organ or a peremptory norm of general international law. However, it had certainly been better and, of course, more in conformity with Article 53 and 54 of the Vienna Convention on the Law of Treaties. If it had added that any agreement entered into by and state party in respect of the area and its resources in derogation of the principle of common heritage of mankind would be void. However, as pointed out by Ambassador Abid Pardo of Malta, no doubt the declaration of the seabed and its resources as the common heritage of mankind was bound to change the structural relationship between rich and poor countries, and that change amounted to a revolution not merely in the law of the sea but also in international relations. Significance of the 1970 Declaration of Principles. Although the above principles were contained in a Central Assembly resolution, which is generally said to be of recommendatory character only, many of these principles have assumed added significance as there emerged general consensus of the states on them in the sessions of the Third UN Conference on the Law of the Sea, and most of them have incorporated the Convention of the Law of the Sea. Resolution 2749-25 of the General Assembly, which incorporated the above principles, was adopted by 108 votes to none, with 14 abstentions. Since no state voted against it, it may be said to have been adopted unanimously, even though the states who on 17 December 1970 did not vote in favor of the resolution subsequently supported it. Besides this, the principles contained in the said resolution have been recited and reaffirmed in subsequent resolutions of the General Assembly. Thus, the principles declared in the said resolution are such as cannot be violated by member states and they all govern the area until all international legal regime over the area is established. Resources of the International Seabed Area and UN Convention on the Law of the Sea 1982. On the basis of the report of the UN Seabed Committee, the Third UN Conference on the Law of the Sea held its first session in New York in 1973. By the end of the ninth session, consensus had emerged in respect of most of the issues relating to the legal regime of the area. After the end of the 11th session on 30 April 1982, the draft of the convention was adopted by an overwhelming majority of 130 states. Finally, on 10 December 1982, as many as 119 states signed the convention. By 31st January 1995, 159 states have signed the convention and 72 states have ratified it. As of June 2015, 167 countries, 166 countries plus European Union have become parties to the UN Convention on the Law of the Sea. It may be noted here that the wealth of the sea is estimated at $300 billion, but it could be several times more than that amount. One of the most valuable resources on the bottom of the ocean are the black potato shaped mineral rich manganese nodules. Indeed, the immediate commercial focus is on these nodules, which are driven across the seafloor. The manganese nodules contain as many as 40 different metals, but the principal component of these nodules is manganese, nickel, cobalt, copper, zirconium, and iron. According to the experts, bottom of the ocean contains copper enough to last the entire world over 600 years, compared with 40 years reserves on land. So is the case with nickel and aluminium. There is enough nickel to last 150,000 years or as compared to 100 years. Reserves on land and aluminium enough for 20,000 years compared with 100 years reserves on land. Thus, manganese nodules are the largest mineral deposit on its planet, but for exploiting and processing these metals, highly sophisticated technology is required. Deep seabed mining and processing technologies processed by a few corporations belonging to the industrialized countries. The corporations which are engaged in development of deep seabed mining technology are American, British, French, Belgium, German, Dutch, Australian and Japanese. As pointed out in the report of the Secretary General, fewer than 10 ventures are likely to become operational within the next decade. The consortia or corporation belonging to America have already invested $200 million for developing deep seabed technology and command a considerable lead over others. Thus, the exploitation of the resources of the area will result in direct and immediate benefits to these corporations and ultimately to the few industrialized countries to which these corporations belong. These few industrialized countries also happen to be the major importers of the minerals to be exploited from the area. On the other hand, there are about 20 developing countries who are the traditional exporters of the minerals to be exploited from the area. The commercial exploitation of manganese nodules will cause a decline of the prices of these minerals, thereby adversely affecting the export earnings of the land-lease developing producers of these minerals. There was therefore an urgent need to prevent or at least minimize adverse effects of the exploitation of the resources of the area on these land lease producer developing countries of these minerals. Consequently, before establishing a legal regime of the area, it was necessary to settle two major issues. One is system of exploration and exploitation of the area, and two is production policies. Both these issues generated a lot of controversy during the third UN Conference on the Law of the Sea, hereinafter referred as UN clause. System of exploration and exploitation, or who may exploit the resources of the area. The developed and developing states took diametrically opposite position in this respect. When the third UN clause started negotiations in this respect, the developed states wanted free and non-discriminatory access to the resources of the area on the condition that a part of the revenues earned would be given to the International Seabed Authority. On the other hand, the developing states took the position that since the area and its resources have been declared as the common heritage of mankind, the exploitation of the resources of the area will be carried out by the enterprise seabed mining arm of the proposed authority. After prolonged negotiation, a package or compromise was evolved, reconciling, reconciling the above opposite positions. This compromise is known as the parallel system, which may be summarized in the activities in the area may be carried out by the enterprise and state parties or state entities in association with the authority. Activities in the area shall be carried out and controlled on behalf of mankind as a whole. States, parties, or states entities will be allowed to exploit the minerals of the area on the condition that for mining a site they will have to submit an application covering a total area sufficiently large and of sufficient commercial value to allow two mining operations within 45 days of the receipt of which commercial value to allow two mining operations within 45 days of the receipt of such application along with data concerning polymetallical modules. The authority shall designate the part which is to be reserved solely for the conduct of activities by that authority through the enterprise or in association with the developing states. Each operator other than enterprise will be allowed to exploit minerals only if he undertakes to transfer technology to the enterprise. If the operator himself is not the owner of the technology, he shall obtain a written assurance from the owner of the technology that he shall transfer the same technology to the enterprise if and when requested by the authority. This will also apply to a developing state or a group of developing states which has applied for a contract to mine states. The obligation to transfer technology shall be included in each contract for the conduct of activities in the area until 10 years after the enterprise has begun commercial production of minerals from the resources of the area and may be invoked during that period. The system shall continue for an interim period of 15 years. After 15 years, a review conference shall be held to see whether the parallel system has worked properly, that is, to see whether the reserved areas have been exploited in an effective and balanced manner in comparison with non-reserved areas and whether the system has resulted in the equitable sharing of benefits to be derived from exploitation of the area taking into particular consideration the interest and needs of the developing countries.